Hello.
Good morning, sir.
Good morning, ma'am. Am I audible? Am I audible?
Yes, sir. You are audible, sir. Just
Okay.
give us 2 minutes. We are connecting to the live.
Sure. Sure.
Twenty-four participants.
Very good morning to one and all. Who stops learning will perish. Who likes to flourish has to continue their learning. Innovation only survives when people believe in their own ideas. With this, I, Aishwarya, from PG Department of Computer Science, on behalf of Kasturba Gandhi Degree and PG College for Women, Management, Principal, Dr. P. Sunita Madam, Vice Principal, Dr. Rajshri Madam, and my dear colleagues, I feel honored to welcome you all for today's webinar on intellectual property rights. Now, I would like to call Dr. K. Sunita Madam, Head PG Department of Computer Science, to address the event today.
Good morning, one and all. I would like to introduce TLC Center This TLC center has been established to accelerate teaching learning process. We have initiated TLC, through which we have been conducting various programs like going online through Google Classrooms. This program demonstrated how to go online using Google Classrooms for conducting classes, internal assessments, and also submission of assignments during the pandemic. Subsequently, we have conducted a webinar on academic writing and research methodologies, which help the faculty and students to publish research papers. In continuation of TLC events, we are organizing today's webinar on IPR, Intellectual Property Rights. Aishwarya, you can continue.
Thank you, ma'am. I extend a warm welcome to our speaker for the day, Professor G. Reddy, sir. Thank you for your presence, sir.
Thank you. Thank you.
I would like to introduce about today's topic, IPR. IPR means intellectual property rights are the rights given to person. They usually given the creator an exclusive right over the use of his or creation for a certain period of time. IPR is very important for economy and for its further growth in various fields such as research, innovation, employment. IPR ensures that the creator holds the sole authority of his creation. Now, I request Ms. Sandhya Madam from MBA department to introduce today's guest speaker.
Oh, thank you, Aishwarya. Respected guest of today, Dr. G.B. Reddy, sir. Beloved Principal, Dr. Sunitya ma'am. Vice Principal, Dr. Rajshri ma'am. Director, Department of Business Management, Professor Neela Kameshwari ma'am. Convener of the webinar, Dr. K. Sunita ma'am, Head Department of Computer Science. And the team of Teaching and Learning Center, faculty, and my dear students. A very good morning to one and all. Today, I am Sandhya Rani, Assistant Professor, Department of Business Management, would like to take the privilege of introducing the resource person of today's session. Strong IP rights helps consumers make an educated choice about the safety, reliability, and effectiveness of their purchases. So to get an awareness about intellectual property rights, we have amongst us Dr. G.B. Reddy, sir, who is currently Professor of Faculty of Law, Osmania University. Sir is a lawyer turned academician, and he has done his PG diploma in human rights from University of Hyderabad and PhD in law from Osmania University in 1999 on the topic Supreme Court and Judicial Activism, its contribution in specific areas of constitutional law after 1980. And his area of specialization is constitutional law in LLM and judicial activism in PhD. He specialized in the area of intellectual property as an independent researcher, publisher, and teacher. He has a brilliant academic record with 3 gold medals in LLB and 1 gold medal in LLM, apart from being the first candidate to have qualified for UGC JRF in law from Osmania University in 1993. And he also practiced in the High Court of Andhra Pradesh for about 7 years before joining the Faculty of Law of Osmania University. And he authored around 20 well-received books in law, including Women in Law, Intellectual Property Rights in Law, Copyright Law in India, Practical Advocacy of Law, Right to Information in Law, and Judicial Activism in India. And 2 of his books, namely Women in Law and Judicial Activism in India, have been reviewed favorably in the book review section of The Hindu by Justice V.R. Krishna Iyer. He also published 56 articles in standard national and international journals and participated in several national and international seminars, workshops, and conferences, and presented papers in Japan, Malaysia, Hong Kong, Singapore, and South Korea. He worked as a principal, head Department of Law, Osmania University from April 2005 to May 2008. And during this period, he introduced LLB 5 years integrated course at University College of Law and PG College of Law. And he also introduced the different courses like different diploma courses with LLM in the areas of intellectual property rights, alternative dispute resolution, and international trade and economic laws, and PG diploma in cyber laws. And he has been a visiting faculty at several reputed institutions, including the AP Judicial Academy, AP Excise Academy, AP Police Academy, National Police Academy, Nalsar University of Law, and the International Industrial Security Academy, and academic staff colleges of Osmania University, Acharya Nagarjuna University, Bangalore University, VIT, IIT Kanpur, and University of Hyderabad. He was also the co-convener of the AP Law Set and PG Law Set for the year 2014 to 15. He's also the chairperson, Board of Studies in Law, Osmania University. And he's also the director of Osmania University Foreign Relation Office. And he's also a member of General Council of Nalsar University of Law, Hyderabad, and member of State Consumer Protection Council and Hyderabad District Legal Services Authority by the government of Andhra Pradesh. He's also a life member of Indian Law Institute and the Institute of Constitutional and Parliamentary Studies, New Delhi, and the American Studies Research Center. And he's also a member of Telangana State Legal Service Authority and chairman of Ethics Committee of CDFT and member of Academic Council of Nalsar University. Sir, I extend a hearty welcome to the gathering, and with the hope that this session will be an eye-opener for many of us, I conclude. Thank you, sir. Now I request our resource person, Dr. GB Reddy, sir, to take over the session. Over to you, sir. Sir?
Yes, I muted. A very good morning to all of you. Thank you, Sandhya Rani ma'am, for a very generous introduction.
Thank you, sir.
I thank the Kasturba Degree and PG College for inviting me to share some of my views on intellectual property rights. I thank the principal, Dr. Sunita ma'am, then the vice principal, Dr. Rajeshri ma'am, then the head Department of Business Management, Dr. Neela Kameshwari ma'am, and the organizer of this webinar and head of the Computer Science Department, Dr. Sunita ma'am, and other learned faculty members and dear students. Well, I understand that this is an exercise in the direction of maybe the quality assurance and also to introduce an IPR ecosystem in the institutions of higher learning. And honestly speaking, nowadays, almost all the educational institutions are acquitting themselves with the intellectual property rights, intellectual property management, documentation, and some of the case studies as well. The reason being that in the 21st century, everything is related to knowledge. And in fact, we talk about knowledge century. 21st century is the century of knowledge revolution. Then we talk about the knowledge management. Then the knowledge industries, whether it is, entertainment industry, publishing industry, or even the information technology industry, and many more. Therefore, time has come to convert knowledge into property, not the power. Knowledge is power is an old saying, no doubt. Vidwan sarvatra pujyate. So certainly a knowledgeable person is respected everywhere. At the same time, we have come to a stage where the knowledge has to be recognized as property, and knowledge could be a commodity which could be commercialized. The knowledge may be manifesting itself in many forms. Today we are talking about artificial intelligence. We are talking about the intellectual property and the in metaverse, right? We are talking about the 3D technology and whatnot. And in every such field, we come across some nexus with intellectual property. This is one important aspect. I have a very small presentation, and I'll make it. Before that, these remarks may be considered as the introductory remarks. Then another important point is that even the government of India has come out with a national intellectual property policy in May 2016, almost about 6 years back. And it speaks about Rachanatmak Bharat and Srujanatmak Bharat. That is, in fact, the innovative India and creative India. And this is going to, in fact, help us in the near future. Today, I read somewhere, probably in Deccan Chronicle, that as far as the defense procurement is concerned, more than 100 products or parts, they have been removed from the list of imported items, because now our country is in a better position to manufacture them indigenously. There is no need of, in fact, importing them from other developed countries. That shows the scientific strength of the country. And we are in the right direction of making more inventions or adopting more innovative practices, and not only creating and documenting intellectual property, but also successfully and commercially exploiting the intellectual property rights. This is one important aspect. Only problem with the IPRs, or intellectual property rights, as they are popularly called, is that many people think that they belong only to a particular field of education. Many people think that intellectual property means only patents. Therefore, only science, technology, and engineering streams are concerned with that. Right? This is again, a misnomer. What we need to understand is that Ilayaraja is equally concerned about intellectual property. The copywriting, the music composed by him for various movies, right from 1980s till today. You must have read in the newspapers. And many people are applauding him for asserting his copyright in the music composed by him, saying that the producers have long, ceased to own the intellectual property in the musical work. It came back to the music composer. Right from that time to, in fact, geographical indication protection, which is given to rohu fish. And in fact, Bihar is one of the states now which says that rohu fish must be a kind of agricultural product which must be given GI protection, what is called the geographical indications protection in respect of Bihar, because that particular fish is produced or cultivated only in that particular area. Another important thing which probably you may relish is that this is the Ramzan season. Go to Pista House or Hyderabad House or any other house, you come across long queues, especially in the evenings, for the sake of Halim, Hyderabadi Halim. But what we need to understand is that this Halim is available throughout the year now, not only during the 40 days of fasting during Ramzan month, because it is given a kind of IPR protection called, GI protection, geographical indications protection. We can give any number of examples which touch our daily lives. And whether it is any of the products which are being used by us in our daily life or any services availed by us, then we come across number of marks, commercial designations. Even a toddler who is about 3 or 4 years old, he'll be happy only to have an Apple phone, iPhone, not any other phone. No doubt it may be providing good quality and efficiency, but the brand value is such that we are talking about the costliest, brand in the world, the value of which is more than 60% of the total assets of Apple company. Only one trademark, is worth that much. Therefore, what we need to understand is that intellectual property is one subject which is interrelated, interdisciplinary. It touches upon almost every aspect of human life. It belongs to almost every field of learning. Persian or, or Telugu or English literature onwards, till the law, management, science, technology, commerce, whatnot. And we speak about many things like, intellectual property valuation, intellectual property audit, intellectual property management, intellectual property rights enforcement, intellectual property vigilance, and whatnot. And this happens in almost all the countries in the world today. Even Ukraine, for example, today, which is under attack from Russia, illegal attack, not legal. But still, if you look at those people who are living in Ukraine, are the citizens of Ukraine, you will find that they contributed a lot to the science and literature. There are a number of, even Nobel Prize winners from Ukraine. Point I am trying to make out is that it is related to every geographical region, every individual. Grandmother also is associated with intellectual property, right? I'll give some other example. About few months back, there was a controversy about a folk song called Saranga Darya. You must have heard about it. And in fact, that song became very popular because of a Telugu singer by name Mangli. And she spoke in she sang in her unique voice. It became very famous. But actually, another singer by name Komali, she came forward saying that actually this is a folk song which she collected from her grandmother. And as the collector, she has the copyright, not the composer, but collector. And she also sang that song in her unique style. So folk culture, folk art, traditional handlooms, traditional handicrafts, traditional cultural expressions, traditional knowledge, the way the different dishes are cooked, the day the agricultural farming takes place. Maybe, there is one gentleman called Chintala Venkat Reddy. I think he got an award also, Padma Shri, if I am not mistaken. He's a farmer from the Salwal area. And he invented new systems of agriculture, recycling of the, in fact, the mud or gravel, whatever it is, which is used in agriculture. And that is also something related to intellectual property. Therefore, time has come for us to realize that we are talking about a subject which is very much relevant, not only in the higher education, but also in our daily life, commercial life, corporate life, life of the nation also. That is one aspect. Second thing, intellectual property, is considered as an academic contribution. In the academic world, people are talking about publications today. I think you are quite familiar with that. They say publish or perish. But we are also coming across sayings like patent or perish. If you don't apply for patents, if you don't make inventions, then what exactly are you going to claim that you have achieved academically? Take for instance the IITians, the people from eminent institutions or schools of excellence like IITs, IIMs, or Indian, in fact, this Institute of Science, Bangalore, and there are many more. You must have seen that the kind of patents owned by them, obtained, owned, and commercially exploited by them, they are phenomenal. Today, if anyone says that eminent universities like Harvard University in USA, they run only on the income, based on the income earned by way of academic patents and the royalty received on licensing those patents, we should believe it. It's not the government funding anymore. Therefore, there are universities of eminence which are running only on the strength of academic patents. And there are number of universities and institutions which are getting better ranks in terms of the NAC accreditation or re-accreditation or whatever it is, in terms of the kind of intellectual property created, the number of patents filed, the number of trademarks registered, the number of designs registered, the kind of work done in the field of IPR. It is one of the most preferred areas. Just imagine, this week itself, I'm going to speak in at least 4 different institutions in 3 different states, only on this. Not because I am the only expert. There are a number of experts. Point is, now it is one of the priority areas for the purpose of, in fact, getting a good rank. And also, that is one aspect, incidental. The other one is to catch our students young. Recently, you must have seen our education minister, Mrs. Sabita Indra Reddy, and Mr. K.T. Ramarao, our municipal administration minister. Both of them were interacting with young students of high schools with regard to the inventions made by them. What a fantastic idea, because everyone has the capacity to come out with something new, to make an invention, to make an improvement over the existing knowledge. And they have a lot of creativity. The present generation has a lot of creativity. Only thing is to identify such caliber among the students, researchers and faculty, scientists and others, and to bring it out in the form of certain intellectual property rights, whether in the form of authors' rights like copyright, or performers' rights, or trademarks, or commercial marks, or industrial designs, or geographical indications of goods, and of course plant varieties. Then the layout and integrated designs, and of course patents. This is one important issue. So let me make a small presentation to you. Probably, nowadays, even if you speak something very meaningful for half an hour or 1 hour, it is not a substitute for our PPT. I don't believe in the total usage of PPT, but nonetheless, it is a handy tool. So let me, in fact, make a small presentation. I think it is disabled. Kindly, enable the presentation. I'll be happy to share.
We are doing so. Just a second.
Please.
So now you just share the PPT stuff. Can you share it?
Yeah, I can share, but only problem is you are sharing facility post to disabled attendee screen sharing. That's the message I'm getting. Do you want me to send it through WhatsApp, ma'am?
No need of it, sir. You just share with it, sir.
No. See, when I am pressing this share screen, disabled share, post to disabled attendee screen sharing. That's the message I'm getting.
Okay.
No issue. If it's any technical problem, then we'll continue.
No, sir. Now you just see it, sir. I just made the change.
Okay. I think yes, I can. Yeah, I think you can see this now.
Yes, sir. We can see.
Okay, sure. Yes. Well, this is one statement which is really interesting. The very first one. In 1997, when in fact, Bill Gates became the richest person in the world, there was a write-up in Harvard Business Review, September issue. There, the author made this statement, because the richest person in the world just before Bill Gates became the richest person in 1997 was Sultan of Brunei, and who was a merchant in oil. Because of oil, he became the richest man. Therefore, the analyst says that for more than a century, it was the oil workers who were the wealthiest, and for the first time, a knowledge worker became the richest, because Bill Gates capitalizes or commercializes the knowledge in the form of, information technology and related aspects. Then another important aspect is this. We have to remember the famous words of Albert Einstein, who says that imagination is more important than knowledge, because knowledge comes from imagination. We see the kids, they're trying to make some pictures in the air or circle this and that. We shouldn't treat it as something, some kind of obsession. Honestly speaking, that is their creativity. Then the last one I mentioned, because we are talking about the Creative India and Srujanatmak, that is Bharat and Rachanatmak Bharat. This is the vision statement of the national IP policy. What is important is this: the knowledge owned is transformed into knowledge shared. Only when that takes place, certainly the intellectual property can be used for the benefit of one and all. And who are the modern knowledge workers today? You can see these 4 photos. The first photo known to everyone, Michael Jackson. But if we try that pose while dancing, we will fall flat. Our nose will be punctured. But neither Michael Jackson nor his troupe fell down, even though they were leaning forward by 45 degrees. The reason was that here in the shoes, a particular technology was used, which was patented, that prevented them from falling down. And Michael Jackson himself was the patentee. Harry Potter series, very well, J.K. Rowling, she's the richest author today. And at one point of time, her income was more compared to Queen Elizabeth II. As an author, she could get so much income every year. Is Bill Gates, very well, what kind of revolution he has brought in the field of information technology. Here it is not a creator here. This is called Harvard Onco mouse. And this mouse was created by the scientists of Harvard for conducting cancer research. And it was patented. This, Onco mouse, lab created mouse, was patented. This is another important aspect. Then the question is, what is intellectual property? Very simple. We are talking about a property which is not visible to our naked eye, which is intangible property, which is exclusively created by the human mind, or you can call it the mental labor. I request some of the participants to kindly mute their speakers. There is a disturbance. There is a disturbance.
Even I understood what he said.
Organizers, kindly mute all except me. Okay. Anyway, we are talking about the intellectual property rights, the rights which result from the intellectual activity, and it may be in any field, maybe scientific, industrial, literary, or artistic field. When we are talking about IP rights, they are patents, copyright, trademark, design, traditional knowledge, or geographical indications of goods. And today, intellectual property encompasses many areas, as I said in the beginning. It may be culture, heritage, technology, or it may be even science. And intellectual property is not confined to technology alone. Another unique thing about intellectual property is that it has no territorial boundaries. What is created in India, it can travel to United States or China within no time without, in fact, making copies of this creation. And the original will remain with us only, but the information will pass to other countries. So therefore, there is no territorial boundary. You can call them transnational in character. Last point is that intellectual property, suppose you make an invention, you apply for a patent, you get it. You will be protecting your patented invention only for a period of 20 years. That is from the date of application to date of, the date on which 20 years term expires. This is a limited monopoly. After that, the technology comes into public domain. The product comes into public domain. If it is a copyrighted work, you write a book, you will be protecting copyright in it during your lifetime plus 60 years thereafter. After that, it comes into public domain. If it is an industrial design which is created, then that industry, our NFT, NIFT, technology people, they may create number of designs, maybe textile and others. How long can the designs be kept in the private domain? They will be protected only for a period of 10 years. If they are so important, they can be extended by 5 more years. But after that, they come to an end. This is another important point. And IPRs are everywhere. I think you can see, if you look at, of course, nobody is using Nokia phone today. They are more concerned about iPhone. But in the phone, you have at least 5 different kinds of intellectual property rights. The brand name, I mentioned about Apple, Nokia, Samsung, it's there. The external appearance, it is nothing but a design, industrial design. Then the technology is used. You talk about, Android or, iOS or something else that is patented. Then the SIM card will have a layout design. So it is protected as layout and integrated circuit design. Then we also have the software. The software may be copyrighted because computer programs are treated as literary works for the purpose of copyright protection. So just look at yourself, you will come across some intellectual property right or other which you have been using. And these are the main types of intellectual property rights. Patents, of course, inventions are patented. Trade secrets, certainly, as long as they are kept as trade secrets, they are intellectual property. Copyrights, which are given to the creators of the literary works, artistic works, musical works. Then industrial designs, I mentioned already, whether it is, design created by any of the famous Indian designers or anyone else. Then trademarks. Ultimately, I mentioned about Apple. And these are the most well-known, forms of intellectual property rights. There are 7. When you are talking about patents, patents are granted only to inventions. Again, somebody might ask me, what is an invention? Invention can be made by anyone. Invention is a new product or new process. A product or process, which have 3 important characteristics. It must be new. That means there must be novelty. Second one, they must be useful. Useful means, we are talking about utility or industrial application. They must be capable of being used or produced by the industry. Then we have the third one, that is called non-obviousness, or we can call it inventive step. So whatever is invented must exhibit something over and above the knowledge which is, existing, technological advancement, etc. If these 3 conditions are satisfied, any new product or process can be patented. And the term of protection is 20 years. About the trademarks, just now I mentioned. See, in the good old days, the number of goods which were used by the human beings were very few. Number of services were very few. So there was not much difficulty in identifying the product which we want to purchase or wanted to purchase, or to hire any service which we wanted to avail. Today it's not like that, because if you want to buy a pair of shoes, it's not Bata anymore. Bata may be the least choice, last choice of many. We have maybe 100 brands which are in the market. How to identify who are, as to who are producing them, who are marketing them? Normally it is done in the form of trademark. It is Puma, it is Nike, it is something else. All of them are trademarks. So trademarks are the marks which are applied to goods and services which are traded. Services, take the case of insurance, which is a service. Banking is a service. Transport is a service. Aircraft is a service, right? And you come across different service providers. They will also be using their, in fact, different marks. You can call them trademarks. That is one important aspect. And their protection is normally for 10 years if they are registered, and they can be renewed forever. Take the case of Coca-Cola. Coca-Cola was a company which was established way back in the year 1888. Still it is going strong. Yesterday, I think KTR was mentioning about So this Hindustan Coca-Cola factory will be established somewhere in Siddipet district. So even after so many years, 134 years, it's still going strong. The Coca-Cola is a proprietary trademark. Every 10 years it is renewed. Then we also have designs, industrial designs, like the features in a particular goods or article which appeal to our eye. Whether it is textile designs, jewelry designs, or biscuit design, whatever it is, there are more than 30 classes of goods to which designs can be applied. What is important is not the utility, but appearance. How our eyes judge these designs. So they are compulsorily registrable. Initially, they can be registered for 10 years. If anyone really wants the extension, 5 more years, maximum 15, not beyond that. Then we have geographical indications of goods. That is also equally important. GIs, as I already mentioned before, Hyderabadi Halim is a GI. The Bengali Rasgulla is a GI. Or, Tirupati Laddu is a GI. So what is the GI? Some of the goods, agricultural goods, or, in fact, manufactured goods or natural goods, they may be having certain unique features, unique characteristics like the taste, appearance, whatever. It may be because of the geographical factors, like, purely factors like the soil, the rainfall, the climate in a particular area, or maybe because some people living in that area have the expertise and the skill to manufacture that. For example, in India, the first GI was registered with Darjeeling tea way back in maybe in 2003 or so. That's the one. So we have more than 400 GIs today. From Telangana itself, there are a number of GIs. I mentioned about Hyderabadi Halim, or Karimnagar Silver Filigree, so on and so forth. Pemberti Metal Craft. Copyright is another one which protects the expression of an idea. Copyright protects expression of an idea. Expression must be original. Idea may or may not be original. Same idea can be expressed in different forms. Ramayana is expressed in different forms by different commentators. You know that. Valmiki Ramayana, Tulsi Ramayana, Mulla Ramayana, Kamba Ramayana, like that. Idea is same, expression is different. Each one of them will have, copyright in it. And right from literary works to musical works to artistic works, dramatic works, music, in fact, cinematograph, films, photographs, in everything you can claim copyright. That is one. And the maximum time of protection is on your screen. The new plant varieties can be protected because the existing varieties, anyway, they don't have any IPR protection. But the new plant varieties, go to the market. How many kinds of brinzols do you find? How many kinds of tomato you find? How many kinds of roses do you find? Whether any one of us really, imagined that there would be roses in December, or there would be roses in black color or blue color. Today you have all of them. Plant varieties protection. If the new plant variety which is created is, in fact, novelty must be there. Then they must be distinctive. Then they must be, useful, and they must be uniform. And the last one is the ND stable. They must be stable. NDUS. These are the 4 conditions for plant varieties protection. Same is the case with integrated circuits. Probably you can recollect one of the movies of Allu Arjun, maybe Arya 1 or 2, where the heroine was obsessed with only cell phones. She would be breaking them. Kajal Agarwal. And if you break the cell phone, what you will find is integrated circuit inside it. And these circuits are also intellectual property rights. I think this is another important area. All the intellectual property rights are not similar or same in nature. Some are related to industrial property, where these 4 different kinds of property can be used or produced by the industries proper. Inventions, they may be produced by the industries. For example, somebody invented, let us say, telephone, Graham Bell, Thomas Alva Edison, bulb. Today, many people are coming out with their inventions. Where are they produced? When the patents are granted, they are produced in a factory, in an industrial ambience. So same is the case with trademarks. Apple is produced in an industry, and this is applied the mark, whether it is Apple or whatever it is applied in the industry. Same is the case with the designs as well as GIs. They come within the meaning of industrial property. Then there is another kind which is more concerned about the culture, heritage, so on and so forth. So there may be copyright, there may be neighboring and related rights, and in the books, literary works, artistic works, musical works. Ilayaraja, I mentioned already, recently filed a case against many music producers, the cinema producers, saying that he is the copyright owner of the music composed for the films. And for 5 years, it was assigned. After that, it comes back to him. Maybe the producers were not so cautious. And today he is waging a very strong battle in various courts, including Madras High Court. In 21st century, you come across other kinds of intellectual property. We're talking about plant varieties, I mentioned already, life forms, even microorganisms which are created in laboratory conditions. They also can be protected. Then genetic resources and traditional knowledge. This is another area which is considered as intellectual property. And recently a bill has been introduced, probably in the month of April, to protect the traditional knowledge. Then layout designs, I mentioned already. Business methods, nowadays they are protected as IPRs, including computer programs. This is one important area. Anyway, then one more point, I think, which our students and faculty members may recollect, that the introduction of WTO, the World Trade Organization, in 1994, and various trade agreements entered under the WTO, that is, including TRIPS agreement, TRIMS agreement, agreement on agriculture, like that. They have made huge impact on the protection of, in fact, not only the trade related rights, but also intellectual property rights. TRIPS denotes the agreement on trade related intellectual property rights. India has been a signatory to this, and we had certain obligations to be fulfilled by the year 2000, though we signed it in 94. And it says that all the inventions must be granted patents, whether it is products or processes in almost all the fields of technology. This is one. Then because I'm drawing your attention to this, because in many countries, including India, product patent in respect of 3 inventions was not granted. Food related, pharmaceutical related, or chemical related. So only process patent was granted. End product was not patented. That gave some kind of leverage to the pharmaceutical companies in India to reverse engineer their, inventions and come out with different names. Simple logic. Today, if you ask for Pan-D tablet, like, it's a gas tablet. And if you go to Apollo, they say, no, sir, this Pan-D is not there, but same formula, different product is there. And it may be much lesser in price. Whereas Pan-D may be costing 150, 170 rupees. This may be costing only 100 rupees. Why? Because 2 reasons. One, even though there was a patent, probably the patent expired, all the others are using it. Even if there is a patent, if it is reverse engineered, then ultimately product will be different, even though formula may be almost same. Product to patent gives more control over the patented, thing. Only they can reproduce, they can manufacture, others cannot. But this kind of control or monopoly was not given to those inventors in the field of food, pharmaceuticals, and chemicals. And the TRIPS agreement addressed this issue in 1994, and they said that all the member countries must give both product patents as well as process patents. This is one important area, right? And of course, TRIPS agreement should make especially those who are studying the business management or commerce, they will definitely find TRIPS agreement to be very useful. Nowadays, many, in fact, biotechnology related inventions are made out. Take, for instance, in 1873, Louis Pasteur patented his first, improved yeast making method. And he got the patent from, French patent office. Then in 1977, there was an application for chimeras, means transgenic animals or plants. They are called chimeras. Of course, it did not materialize. Then in the field of DNA sequences in plant species like maize, cereals, and pulses, fruits and vegetables, they came to be patented since 1980s. Today, even microorganisms are patented. Microorganisms are, those very minute, tiny microorganisms which are created under the laboratory conditions, which are not naturally created. That's very important. If they are naturally created, sexually produced, then there is no question of granting a patent. But if they are not biologically produced, but produced under laboratory conditions, even microorganisms can be patented. This is the practice from 1980s onwards in USA and other countries, right? About the GIs I mentioned already, they apply only to the goods which are agricultural, natural, or manufactured. Then these characteristics are unique because they are relating to their geographic place. It may be the size, it may be the appearance, it may be the quality, whatever it is. So it may refer to indications of source and appellations of origin. Indication of source means they are coming only from that source. If you say Simla apple, it comes from Simla only. You can't expect this to be Hyderabad apple. So indication of source. The other one is appellation of origin. Appellation of origin means that originally it came from that, but today it is produced everywhere. You talk about champagne. Champagne is some kind of sparkling wine which is produced from the grapes, right? And that too, these kind of grapes once were produced only in central France, right? And from that only, they used to produce champagne. But today, I think champagne is produced throughout the world, and it's not the Charmina, France alone. If you talk about Paris perfume, I think even our old city also produces perfume of different kind. They can call it Paris perfume. The origin or the first source will be remembered, but it can be produced everywhere. So some of the best examples of geographical indications are on your screen. We have champagne, which is a wine, sweet chocolates, Florida oranges, Tuscany olive oil from Italy, Tirupati laddu, Kullu shawl, Mysore sandalwood soap from different areas in India. Then geographical indications of goods are unique because no single individual can claim any kind of right as far as these GIs are concerned. It belongs to the group. I'll give you a small example. Sometime in 2004 or 5, Pochampalli Ikat was registered as a GI. That's in the Pochampalli village of Nalgonda district. And this Ikat or motif, whatever it is, only 30 or 31 families of Pochampalli village, Budan Pochampalli village. These weavers alone, they got that protection. And they have the right to use this Pochampalli GI. And if anyone wants to transfer it, they cannot, because it is collectively owned. It can be only inherited, but it cannot be transferred. This is one. As I said, 417 GIs got registered as of 16th November. I think now the number is more. For example, from Telangana state, you come across Telia Rumal. It is from Nalgonda. Warangal Duris, Adilabad Dokra. There are almost 16 different kinds of geographical indications from Telangana. Then, of course, another point also you must understand. Intellectual property, though it may belong to a particular area, others may try to steal it, steal the knowledge. They may claim the credit without any justification. Ongol bull, you can see on your screen. But today, you ask any Brazilian, they say that no, it is Brazilian bull, not Ongol bull. Why? Because somehow the DNA etc. of Ongol bull, it got transported to other countries. Now they are claiming they are producing similar kind of bulls, and it is nothing but biopiracy. Similarly, same thing happened in the case of certain spiders. They are called Indian tarantula, tiger spiders, and ultimately they found that they were exported to be used as in fact some kind of exhibition items, sometimes to take out the venom from these spiders. Same thing happened to even certain entomologists who work on insects, and a Czechoslovakian entomologist was jailed in India for exporting butterflies, Indian butterflies from Darjeeling region of West Bengal. Some example. Then another point, this is basmati rice, everybody knows. If you want to eat biryani, better eat only basmati rice biryani. But somebody from USA wanted to patent it. Sometime in 95, a corporation called Messrs. Rice Tech Corporation, they came forward with an application stating that they have come out with a new variety of basmati and they wanted a patent for it. We objected. We won the case because we said that this kind of basmati can be grown only in Himalayan foothills, and the existing climatic conditions really help in such a rice getting such a quality. Same thing, some people wanted neem to be patented. For instance, neem can also kill the insects or even fungus also sometimes. It can be used as a fungicide. Somebody made an application in European Patent Office. An American company made an application in European Patent Office to get a patent for neem to be used as a fungicide. But again, the Indians objected to the same, saying that here it is our traditional knowledge. Every household uses neem as some kind of antiseptic. This is another one. Same thing happened with regard to turmeric. And in fact, Americans wanted to patent turmeric and its wound healing characteristics. I think it's quite common nowadays. If there is a small cut on our hand, leg, or forehead, whatever, I think our mother or grandmother, whoever is at home, if there is no other first aid, they would apply the turmeric powder, and the bleeding will stop. The marks will disappear after some time. So it's an antiseptic. And in fact, 2 Indians wanted to get a patent for it in USA. Probably they thought that in USA nobody knows about turmeric and all. But somehow we came to know, we in the sense the Indian government, and we objected to the same and we have succeeded. That's another important aspect. Then we also have, this is the essence of, the biopiracy, whatever happened. And these are some of the decisions. Yeah, here is a very interesting thing. The name of this pig is Picasso. You know that Picasso was a famous painter, artist. And this pig is called Picasso. And the speciality of the pig is that it's a wonderful painter. You just give it a brush and, colors, it will splash in different, just see how it was painting. There are videos of Picasso in YouTube and Google also, you can find out. So it created a beautiful painting. An animal is creating, but who will have intellectual property right in it? Can the animal say that these are my intellectual property rights? So this is a new challenge now. Even animals are creating. Look at this. This is a very, very interesting episode. A British natural life photographer by name David Slater. He was conducting research or making a study of, the chimpanzees, black chimpanzees in Indonesia. They are called maccays, crested maccays. And, in fact, he found that one day when he was away from his camera, one of the, or maybe 1 or 2 monkeys or chimpanzees, they took a selfie. Chimpanzee taking a selfie. The chimpanzees are very clever. They observed how he was taking pictures or selfies. They also took the selfies. He sold the photos to various organizations, including Time magazine and all. This was objected to by certain persons, stating that, in fact, in the instant case, if there is a copyright assignment, if any income is created, it must go to the monkey because it took the selfie with the help of a camera, but not the photographer. But the American court ultimately dismissed the same. In fact, that a non-human being cannot hold copyright. So monkey being a non-human being cannot exercise or cannot hold copyright. This is another important aspect. Yeah, this is another very important development nearer to our place, our home, Telangana, Andhra Pradesh, Nalgonda, whatever it is. Point is, here, Chintakindi Mallesham, the movie also came. Priyadarshi played the role of Mallesham. And in fact, he came out with a machine called Asu making machine. He called it Lakshmi Asu making machine because Lakshmi is the name of his mother. With this machine, weaving becomes very easy. One need not personally move the hand. The weavers traditionally, what do? They simply, move the hand up and down some thousands of times every day. What will happen to their joints? So when he saw his mother suffering, this 8th or 9th class dropout, he came out with this invention, Lakshmi Asu making machine. And it was considered as one of the most notable rural inventions in the country. So this is another one. Chintakindi Malaysia movie you can watch. And this is a classic example, friends, that in order to create intellectual property, one need not have PhDs or technical degrees. Imagination is more important, as pointed out by Albert Einstein. That is another important aspect. Well, there are many more. So we are talking about, Tesla. The owner of Tesla says artificial intelligence is a dangerous thing, but he uses that artificial intelligence thing even in the Tesla cars. And who knows, tomorrow there will be driverless cars on the streets of Hyderabad or Indian roads. Quite possible. And that is also intellectual property. What they say is electric cars will be replacing the gasoline cars or the cars which run with the petroleum or diesel. This is another one. And of course, computer programs are also protected by way of, in fact, copyrighted works. There are a number of cases for your information. There are cinema cases, whatever it is, issues relating to cinema, authorship of the musical work, or the singer's rights, assignment, so on and so forth. What you need to understand is that the places of higher learning like Kasturba College or Usmania University or any other university for that matter must have an IPR policy drafted by the competent or expert groups that will help them in documenting IPR, then also in protecting or promoting the IPR protection, right? So universities will do well to come out with their own IPR policy. And I hear you may, in fact, quote Mr. Sam Pitroda, who was the chairman of the National Knowledge Commission. And in his second report, he says this: when we are talking about IPRs, intellectual property rights, our efforts must go beyond the IP offices. And they must reach out to the scientists and engineers working in national research institutes, universities, industry, the bar, the researchers and students. This is important. But not only in metropolitan areas, but also, in fact, in the smaller towns and the rural areas of the country. So that's what is happening now. But there is a need to strengthen our intellectual property system, and the government is trying its level best to ensure that there is, proper documentation of the intellectual property. This is one. I mentioned about this Creative India and Innovative India, Srujanatmak Bharat and Rachanatmak Bharat. I think I mentioned about it. And what are the major challenges as far as the 21st century is concerned? This is equally important for us. Intellectual property rights are slowly and gradually ceasing to be only individual rights. Today we are talking about the collective rights. I mentioned about a group of people coming out with a creation, a new creation, attracting the intellectual property rights. For example, GIs, I mentioned about the geographical indications of goods. Certainly you have, the collective property of the number of people belonging to that village, that community, whatever it is. That is one. And the new forms of intellectual property rights are occupying the center stage. So today we are talking about not only the human beings creating, but also artificial intelligence creating intellectual property. And now the debate is that if it is created by artificial intelligence, then how to make it accountable for its actions is another important point. So we have to make the concerned AI also accountable for the actions, omissions or commissions. This is one. I already mentioned that knowledge industries today, they make us focus mostly on the related areas like the intellectual property management or valuation or intellectual property audit. This is another important point. So when you are looking at intellectual property, friends, internet is the most fertile area as far as the intellectual property rights are concerned. And when you are looking at this, ultimately the intellectual property rights, you have to understand that there are a number of issues which you have to discuss. Lawyers or chartered accountants or scientists or engineers are not the only ones who are concerned with intellectual property. Intellectual property may be in the form of preparation of a dish, preparation of stained steel, then maybe a perfume, maybe some kind of, business method. All of them are part of the intellectual property. It is interdisciplinary in nature. Intellectual property is interdisciplinary in nature. And who knows, tomorrow the wars may not be physical wars. And certainly future wars will be brought with, in fact, fought with the knowledge and intelligence, which themselves will be the arms. Then intellectual property is not for individual development. When intellectual property is created, commercially exploited, probably it can help the society much better. So what I tried to do during the last 1 hour plus has been to demystify the IPRs. So what exactly are the intellectual property rights, and what exactly is the scope of such protection which is granted by patents, copyright, or trademark, service mark, whatever it is. But before we protect the intellectual property, let us understand what is intellectual property. Let us create the IPRs. We can identify the IPRs which are abundantly available in, in fact, the society. Then we have to document, register, then exploit, and lastly protect. Straight away you can't go for protection. A lot of work needs to be done. So this is a brief presentation which I wanted to make. Now, while I'll stop sharing, if you have any doubts and all, I'll be too happy to answer. And otherwise, anyway, it's over to you. I'm ready for Q&A.
Thank you, sir.
Yeah.
Any queries you can ask, like participants can ask. Sir, like once if we have a patent, how long it is valid, sir?
20 years, ma'am. A patent is valid for 20 years from the date of grant. Date of grant is the date of application. Suppose I apply for a patent today, it is granted after 4 years. So the 20 years period will be calculated from today, from the date of application till the expiry of 20 years.
Sir, whether this patent is like worldwide or regional?
There is nothing like worldwide or global patent. Patent is a national grant. If you obtain Indian patent, it is protected only in India. If you want the same invention to be protected in USA, where you want to commercially exploit, you have to take American patent. If you want it Japan market, is the area where you would like to trade with, then they may be insisting on Japanese patent. So it's a national right, depending on the national registration. But it can be done only within 12 months. For example, I patented my invention in India today. Let us say I applied for it today. Within 12 months, I may apply in any number of countries, right? Then only I will be able to get the patent. Otherwise, after 12 months, the priority period will expire.
Sir, is there any age limit, like minimum age limit for patent?
Absolutely. That you are talking about patentee, the person to whom the patent can be granted.
Yes, sir.
The inventor need not have any specific age, ma'am. A 2 years, 3 years old also can make an invention. A 120 years old gentleman also can make an invention. So there is nothing like age restriction, a condition relating to age.
Thank you, sir.
One more, I can see the chat box. Okay, Sanjay Rani ma'am says, good afternoon, sir. Does IP infringement always give rise to criminal liability? Criminal liability will not ensue in all the cases. For example, if copyright is infringed, there will be civil liability as well as criminal liability, because Copyright Act talks about criminal liability also. Even with regard to trademarks, there is criminal liability. But in the case of patents, etc., it is only civil liability, but not the criminal liability. It depends on the kind of intellectual property. That is important. Not in all the cases that the criminal liability is attracted. If anyone wants to pose a question, they can do so in the chat box. I'll be happy to answer.
Good afternoon, sir.
Yes, ma'am. Good afternoon.
Sunita, sir, I would like to know how we have to patent an idea.
Honestly speaking, if idea remains an idea, it can never be patented, ma'am. But if idea manifests itself in the form of an invention,
Yeah.
it must be in the form of a new product or new process. And if the product or process satisfies three conditions, one is novelty, means nobody must have known about it, or nobody must have been working on it, or published on it. Completely, there should be absence of prior art, prior knowledge, prior working, prior publication. Then you say that there is novelty. First condition. Second one is utility, its usefulness, industrial application. Third one is it must be over and above the existing knowledge, so that even an expert in the field says that yes, this is something new. If these three conditions are satisfied in respect of any new product or process, that can be patented. But simply if the idea is here, there is no protection. Idea must be, yeah.
How to put it forward, sir, the idea?
Point is very simple, ma'am. It is for the individual to, in fact, communicate the idea. Some people write a piece of paper, a research paper, an article, etc. But then if all the details are given in the article, nobody can patent it, because already it is published. The knowledge is in public domain. At the most, they can get some kind of copyright protection. Therefore, the product which is sought to be patented, first, they must satisfy about these three essential conditions. After that, they must make an application through a patent agent to the concerned patent office in India, or maybe even through, the mechanism which is available, like, WIPO mechanism, we call it, World Intellectual Property Organization. There is a mechanism called PCT mechanism to file the patents in other countries. But only thing is, idea must be incorporated in the form of literary, artistic, musical, etc. works for copyright protection. But the expression must be original in the form of trade description, commercial description, trademark, service mark, etc. That is another kind of trademark protection. If it is in the ornament or decorative element in a particular goods, etc., then it is industrial design protection. If you want a patent, then you convert that into a product or process. Process also can be patented. A procedure also can be patented, provided these three conditions are satisfied. Our students can come out with their own inventions, nothing wrong in it. Some engineering college kids, they will be showcasing their innovations and inventions. Here, we must distinguish between innovation and invention. Every innovation is not invention. Innovation means normally a new kind of doing the things, right? And it may be a process. Innovation is a kind of process. But invention, as I already said, must always be in the form of either a product or process.
Thank you, sir.
Yeah, I think one more question. Can you provide what is the educational institutional can patent? There are number of examples, ma'am. In fact, we call them academic patents. We call them academic patents. That means, you know, the patent, the inventions made by the students, or the researchers, or even the faculty members in the course of their research, they can be patented. There are any number of examples. Take for instance, Harvard Onco mouse. That mouse, the picture I have shown in the beginning, that was patented by two scientists working for Mississippi Medical School. They were Harvard School of Medicine, Timothy Stewart and Philip Leder. These two persons, they got a patent for Harvard Onco mouse. And ultimately it is named after Harvard only, Harvard Onco mouse. You can come across any number of academic patents like this. IITians, even our IIT Hyderabad also got some patents. Same is the case with University of Hyderabad. Same is the case with even Usmania University. So today there are 60 plus patents acquired by the, you know, our academicians and researchers, students also. They can do so while working on a research project granted by either Department of Biotechnology, Department of Science and Technology, CSIR, many more funding agencies. So during that process, if they come out with a new invention, it can be patented. Any other questions?
Good afternoon,
I think,
sir.
Yeah, good afternoon.
Sir, if patent is misused, then what kind of penalties there will be?
Generally, there will be only civil remedies. Like, you know, if my patent is misused by you or your patent is misused by me, in such a case, there may be damages, monetary damages which can be claimed. There may be some kind of injunction, a restraining order not to use the patented technology. There may be temporary injunction, sometimes permanent injunction. There may be statement of accounts. And it may be, for example, it may be even revoked. Patent once granted is not permanent. If it is abused, there is a possibility of revoking it, getting it cancelled also. If it is wrongfully granted, then also any other person can oppose. There are two stages of opposition to the grant of patent. Before the grant of patent, even after the grant of patent for up to 1 year. Any person can say that this is not an invention, therefore it can be revoked. If it is properly granted, but someone else is using this patented technology without license from the original patentee, then such a person will be liable for civil consequences. Like, as I already said, maybe injunction, maybe damages, compensation, etc.
Thank you, sir. It was wonderful session. Today we had an opportunity to know the rights, and this will surely be going to encourage us in our innovations. You have enlightened our minds and shown us a new path. It was a great pleasure to listen to your wise words that help magnify our cause in the best possible way. Once again, I would like to thank you, sir.
And I would like to suggest to those who are interested. Yeah, ma'am, give me a minute. Can you hear me?
Yes, sir, I can.
I would like to suggest to those faculty members are the students who are interested in doing something in respect of intellectual property rights. At least in learning, there are certain few online courses which are free from World Intellectual Property Organization. I suggest to them to visit the website of WIPO, WIPO, World Intellectual Property Organization. This is part of the United Nations, and there is one course which is free of cost, DL 101, and this certification will help them in the long run. And there are some paid courses also, depending on their taste: cyber law and copyright, internet copyright, biotechnology patents, or intellectual property management. Like that, there are a number of courses. There is one general course which they can enroll themselves. That is wipo.int. That is a website, wipo.int. There they can look for these courses and enroll themselves.
Thank you for your suggestion, sir. Thank you so much. Now, I would like to call Dr. Kusma Dorcas Madam from Department of Microbiology to propose a vote of thanks.
Good afternoon, everyone. We thank the management, principal, vice principal of Kasturba Gandhi Degree and PG College for giving us permission to organize this webinar. Our special thanks to Professor G.B. Reddy sir for accepting and sparing his valuable time and giving us an insight on IPR and its importance. Our sincere thanks to Dr. K. Sunita, Head Department of PG Computer Sciences, for organizing this webinar. We thank all the teaching staff and students for attending the webinar, and I hope this topic on intellectual property rights will be useful to all of us in near future. Thank you all once again.
Thank you.
Sir, could you please share your PPT with us?
Yeah, sure. I'll send it through WhatsApp to Sunita, ma'am.
Sure, sir. Thank you so much, sir.
Okay, thank you.
Thank you. A gentle reminder, a feedback link will be provided in the chat box or a comment box. Kindly fill the feedback form in order to receive a e-certificate. Thank you. Thank you, sir.
सजेशन मैंडेटरी नहीं है मैंडेटरी डेजिग्नेशन फैकल्टी పెట్టానా You can leave now.